the theme on which I would speak seems very common, very general today, namely secularism. But as I was called upon to speak on secularism to UGC-sponsored workshops, and I don't know for what reason the AMU Staff College made me speak on secularism again and again to teachers who came there, as if I was an expert on this theme. And therefore I had to read up and study the various complications that attach both to its term and to its practical implications. As is well known, in the original Constitution of India, which came into effect from 26 January 1950, the word secularism was not used. The word secular appears in the Constitution in Article 25 when it refers to the secular activity of religious institutions. Here, of course, secular means worldly, and this is the meaning of secularism with which I will start, because the word secular is from seculum, which means world, and so secular is worldly. So worldly activities of religious institutions. Then how come that this word, which literally means worldliness, should now appear in the preamble of the Indian Constitution inserted there in 1976 and under all regimes retained there, by which India now has become a sovereign, socialist, a term which we have forgotten as far as the courts are concerned, secular, democratic republic. So the word secular here has a different meaning than worldly. And what is that meaning? Now, it is here that I think the major point of difference in the interpretations of secularism begin. Because secularism is not what Professor Radhakrishnan thought, as I shall presently see, and what the Supreme Court thinks it is. If you go to the dictionaries, like the Oxford English Dictionary, the monumental one, then it tells us that the word secular was first used in 1851. Secularism was used in 1851 by the political thinker Holyoake. And it is a doctrine that morality should be based solely with regard to the well-being of mankind in the present life, to the exclusion of all other considerations drawn from belief in God or in a future state. Now, this is the starting point of secularism. Secularism to Holyoake and to all political writers and thinkers outside India means that a decision with regard to morality should be taken not with reference to what religion prescribes or what is thought to be good for afterlife according to the opinion or faith of one religion or another, or some superstition or another, but according to what is good for life in this world. That is to say, it rejects the belief in afterlife or the belief in God as any source of guidance for morality and derived from it from policy of the state. In fact, Holyoake said in 1854 that I rejected I tried to use the word infidel, skeptic, atheist, but they do not actually come close to what I meant. I meant that all morality, all policies of state should correspond to what is regarded as good for human beings here. From this, it has got extended meanings. For instance, the view that education or the education provided at taxpayers' cost, public cost, should be purely secular, that is non-religious. Worldly, should include no religious beliefs whatsoever. This is again an important point on secularism, which, as I propose to show, goes against its specific Supreme Court judgment. Modern dictionaries like Merriam-Webster define secularism very briefly as indifference to or rejection or exclusion of religion or religious considerations. Now, of course, this is too narrow a definition. What secularism excludes is interference of religion or considerations of afterlife in determining what is good for humanity. Now, this is the history of the word, but is there also a history of the principle? And I would like to draw your attention to the fact that before the word secularism came, secularism had been instituted without the name as an instrument of policy from 1789 onwards in the French Revolution. Almost every modern value that we speak about, gender equality, democracy, national independence, rejection of slavery, all summed up in the slogan liberty, equality, fraternity. All these modern ideas have come from a single fountain head, the French Revolution. These ideas were not instituted by philosophers. You won't find them in Rousseau. They were instituted by battles in the street. Now, in the French Revolution, the abolition of feudalism decree of August 1789 abolished the landlordism of the church. Other decrees followed, divested the church of the property, its property, and that involved the French state in conflict with the Catholic Church. That conflict went to the extent that the French state not only rejected Catholicism as a power in France, the Catholic Church as a power in France, but Christianity and by extension all religions as influences in state action. Civil law was for the first time in Europe and large parts of Asia perhaps, but at least in large part of the world, for the first time was separated totally from religion and handed over to the state. In violation of every canon of Christian law, daughters were made heirs equal to sons. Marriages were made subject to divorce with equal rights to both parties, but with additional obligation on husband to provide maintenance. Compulsory education from 1794 was promised to every child, boy or girl. Now, these actions are obviously secular actions without the word being there. They denied, the French state denied that Christianity or any religion could play any role in formulating the policies of the state with regard to civil law, with regard to education, with regard to morality, and almost all aspects of state action. This was actually secularism in action according to Holyoake's definition, because the French legislators subjected everything to reason. That was the rule of reason, and rejected the influence of religious belief and superstition. In fact, although I'll be departing from exactly my subject, but let us remember that when Napoleon went to Egypt, he issued a proclamation to his French soldiers. And he said that just as we regard Christianity in France to be false, so we regard Mohammedanism to be false. But just as we tolerate Christianity in France, we must tolerate Mohammedanism in Egypt. In other words, religion was to be tolerated, but that was all. It was to exercise no influence, and to those who were in the know of things was regarded as wrong. Now, wrong in the sense that religion could not interfere with the operation of what was good, what was thought good for the greatest number, to use a utilitarian phrase. Thereafter, in the United States especially, secularism was given a fairly legal form, and in many modern states, including Turkey for example, until some changes have been made by the present government, secularism has been enforced of a sort that would suit Holyoake's definition and also the precedent of the French Revolution. Now here in India, unfortunately, a different definition prevails. And that definition comes from Sarvapalli Radhakrishnan. In a book called Recovery of Faith, Radhakrishnan, who was vice president and then president and previously a historian of Indian philosophy, he writes, when India is said to be a secular state, it does not mean that we reject the reality of an unseen spirit or the relevance of religion to life, or that we exalt irreligion. We hold that not one religion should be given preferential status. The whole concept of secularism is reduced to a triviality. What has secularism got to do with existence or non-existence of an unseen being? If it is unseen, it is probable that it does not exist. So, is it relevant at all to morality? How is it relevant at all to civil law? How is it relevant at all to gender equality? Or he says the relevance of religion to life, but that is the real question. Secularism, in its proper definition, contests the fact that religion is not relevant to real life. Its entire civil law was abolished in the French Revolution. And let us remember that the entire Dharma Shastra was abolished by the Indian Parliament in 1955-56 and replaced by a totally different piece of law which had nothing to support it except reason, the Hindu Code, the 3 acts that constitute the Hindu Code. So what has religion got to do there? Then the whole thing, as I've said, is reduced to a triviality, that in India secularism is special. It hardly means anything. It only means that no single religion should be given preferential status. That is all. Otherwise, religions can have free play in our constitutional life. Now, unfortunately, the Supreme Court has accepted the Radhakrishnan definition and therefore made a triviality of secularism as far as law is concerned. Now, I shall come to Supreme Court judgments on not so much as Hindutva as the religious instruction or instruction in religion that it has made legal presently when I consider the question of religion in education in a secular state. But my first proposition is that India is not exceptional. Secularism is not a thing which can be divided geographically, that secularism is all right in its classical definition, in its French Revolution precedent, for all countries except India. Here secularism is different because Radhakrishnan says so. What is Radhakrishnan's particular authority in either political philosophy or constitutional law, I don't know. If I were to be bitter-minded, I would say that as a philosopher, he accepted knighthood and then went on to say that ancient India lost its philosophical greatness because it surrendered to foreigners. He didn't think that his own taking of knighthood deviated from the great philosophy of Indian history that he put forward there. So I am not at all sure that Radhakrishnan has any particular authority which we should respect. On the contrary, what he is saying is totally contradictory to the general theory of secularism. And my argument is that the first task of Indian statesmen should be to retrieve and restore the definition of secularism. Otherwise, defense of secularism means hardly anything, and all secularism would be, as our BJP friends put it, pseudo-secularism. In the Indian Constitution, as I've said, the word secularism was not used. But the Indian Constitution derived much of its spirit not only from the Government of India Act 1935, unfortunately, but also from the Fundamental Rights Resolution of the Indian National Congress passed at Karachi in February 1931. In that resolution, although the word secularism is not used, certain principles are strongly stated. Every citizen shall have freedom of conscience and the right freely to practice and profess his religion, subject to public order and morality. Morality is different from religion. Religion must be subjected to morality, precisely the Holyoke position. The culture, language and script of the minorities of the different linguistic areas shall be protected. All citizens are equal before the law, irrespective of religion, caste, creed, or sex. Gender equality, as far as also freedom of influence by affiliation to religion or caste, any particular religion or caste or creed. No disability attaches to any citizen by reason of his or her religion in regard to public employment, office of power, and honor. Then finally, the state shall observe neutrality in regard to all religions. Not equal respect for all religions, not equally granting influence on the state to all religions, but specifically neutrality in regard to all religions, which is a far more restricted word than in Radhakrishnan's definition. So actually, one could say that broadly the Karachi Resolution of 1931, which promised Indian citizens what would be the shape of India when it is free, presented a picture of secular India without describing it as such. In the Constitution, there are undoubtedly compromises. Many of the principles stated in the fundamental rights are put in the Indian Constitution, but some exceptions and provisions are provided. One is that religious endowments already adopted, already accepted by the state shall continue. The implication that no fresh religious endowment shall be accepted is unfortunately not explicitly stated. A special provision is made with regard to social welfare and reform or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus, makes a departure from the secular position, because here Hinduism is subjected to a particular political restriction to which presumably other religions are not subject. Other principles are stated which implicitly which imply that religion is not regarded as a welfare institution. For instance, no tax exemption can be granted for promotion of any religion. It means that promotion of religion is not regarded as a welfare activity, which Radhakrishnan thinks it is. Now, before I come to education and the implications of constitutional provisions for education, in the light of what our view of secularism should be, I should like to consider first the question of civil law. Now, if you are all familiar with the fact that in the directive principles of state policy, Article 44 states that the state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. This has been a red herring, and this is a very unfortunately worded statement. What is more important, a good civil code or a uniform civil code? What do you want to do with a civil code? That is not stated. It is not stated, for example, that women's full rights will be provided in the civil code. That is not stated. It is one of those unfortunate insertions into the Constitution which have caused so much disturbance. You don't have to be a Titu like me to remember that when in Parliament in 1955-56 the Hindu Code bills were introduced, only half the share was provided for the daughter in the original bill. And when the question was asked, why only half share, why not full share? The answer was that if daughters are given the whole share, uniformity of civil code will not be possible, because Muslims object to giving more than half the share to daughters. So uniformity was so sacrosanct that all the interests of all the women in India were to be sacrificed in order to have a uniformity of civil code. Members of Parliament were of a different stamp at that time, apparently, and by an amendment, the original draft of the article was rejected and full share was given to daughters. But this is an example of how in the Constitution a mischievous clause was introduced in order to reduce the radicality of the Hindu Code. Those very parties which at that time opposed the Hindu Code in the 1952 election, the Ram Rajya Parishad and the Jan Sangh, which were wiped out, are now using this particular clause to say that a uniform civil code must be introduced. In 1992, or rather 1993, after the demolition of the Babri Masjid, the Indian Express, perhaps by error, asked me to write a piece on it. And I there pointed out that Mr. Advani should say that in a uniform code, the rights of Hindu joint family would be suspended. Because how in a uniform code you could have the rights of Hindu joint family, because a uniform code should not pay any regard to any particular caste institution and religious institution. In his answer to my article, Mr. Advani omitted to discuss this point entirely. And this point has never been explained, whether by the uniform code you would also strike down all the preferential elements that are still provided for Hindu joint family and other Hindu institutions. Nevertheless, it is clear that religious laws must have a limitation. The principle of gender equality is today a principle that overrides all other considerations. If it does not so override, then it means that the government and the state is not secular. We are not where the French Revolution was in 1792 after its marriage and inheritance laws. We are not there. We are not even there. Even after all the amendments to the Hindu Code. It is always necessary, of course, in practice to persuade rather than enforce, if possible. I am all for persuasion. Muslims, Parsis, Christians, all, wherever there is discrimination between men and women, in their personal laws, they should be persuaded to support a change. And one particular measure which would be important would be to extend the inheritance rules of the Special Marriage Act to all persons, irrespective of religion, Hindu, Muslim, Christian, or atheist, or unbelievers, whatever, who register and want the inheritance law to be governed by the inheritance rules provided for in the Special Marriages Act of 1954. Actions like this will then see what the public response is. But certainly it is clear that if India has to be secular, it must enforce modern values, one at great sacrifices through the state, whatever religion or superstition prescribes, over whatever religion prescribes. I again assert that this does not mean that religions are not tolerated, but this does mean that religions must have a domain defined for them, that is ritual and worship and not civil law. And I also stress, I do agree that in order to enforce a law, persuasion is all says, and permissiveness should be first used, and first there should be an instrument of permissiveness, that here is a civil law for all Indians, irrespective of any religion, they can opt for it as a citizen. If this alternative is provided, at least the preference of the state for a particular kind of civil law where men and women are at last equal will be established. The second important point relates to education. The Constitution is exceptionally clear on points of education until the Supreme Court decisions have muddied its contents. I will remind you that Article 29 states, no religious instruction shall be provided in any educational institution wholly maintained out of state funds. This is as clear as can be. You just can't provide religious instruction if you are maintained from state funds. This is not applicable to endowed institutions if the endowment had been previously accepted, and it was under this permission that the Banaras Hindu University and the Aligarh Muslim University are allowed to provide religious instruction, though they are wholly maintained out of state funds. 3. But the third is important. No students in recognized or aided institution shall be required to receive religious instruction or attend any religious worship. They cannot be required as in a compulsory manner by even endowed religious educational institutions and by institutions which do not receive aid, but have recognized diplomas, degrees and certificates. This is not in conflict with Article 30, and that is one doubt which must be cleared: the right of minorities to establish and administer educational institution of their choice, religious and linguistic minorities. A minority institution remains a secular institution. It is directed to the education of a minority, linguistic or religious, but is not itself, cannot itself be a religious institution. because Article 30 must be read with Article 28. Now, unfortunately, this provision of law, constitution, was clearly established and to some degree followed in practice until the BJP government came into power and changed the syllabus, NCERT's recommended syllabus, prescribed syllabus for our school system. You remember that controversy from 2000 onwards. Whereas the Constitution says that no religious instruction shall be provided, Mr. Murli Manohar Joshi and his associates came forward with the very bright idea that though religious instruction may not be provided, instruction in religion can be provided. Now, all the daily newspapers that I read at the time smiled or laughed at it as you are doing now. No newspaper took it seriously. And when they still put it into practice, and as may be expected, instruction in religion meant that 9/10 would be Hindu religion and 1/10 would be shared by Islam, Christianity, Sikhs, Parsis, and other riffraff. The 9/10 would be on religion, Hindu gods and deities, or in Indian history, the Hindu religious places. Though the accuracy was remarkable, the statement began in the history textbook that Hinduism is the only religion whose holy places entirely are in India, and the first holy place it so described was Kailash, which, as most of you would know, but the author did not know, is in China. So, so this was what was not only the rejection of the constitutional provision, but also the celebration of ignorance was the hallmark of the NCERT syllabus. In fact, Indian History Congress published a whole book, Index of Errors, and one of the authors said, this is all right, in the next edition they have done a good job, we will remove the errors. They never did, because by removing those errors they would have divested their books of religious instruction. So anyway, it came before Supreme Court. Some distinguished educationists went to the Supreme Court. Now I have been worried not only about the ideas of the high courts and Supreme Courts, but also about their English. This 2002 judgment is remarkable on both counts. There are sentences without verbs, and the word sant, perhaps why I don't know, I am not a Sanskritist, is uniformly spelt sant with an H, TH. So this judgment pronounced, contrary to all known history, that all the great moral ideas have been, and social ideas have been prescribed by saints and saints. They never heard of the French Revolution, they never heard of the Soviet Revolution, they never heard of democratic changes in Europe or secular laws in Europe. All good things belong to saints and saints. And therefore, because all the fundamental rights in our constitution come from saints and saints, instruction in religion is necessary for the defense of the constitution. So false history and a dangerous inference. False history is that there is not a single important fundamental right you can choose at random and see whether sons and saints first gave it, or irresponsible rebels gave it first. People like Robespierre and Danton and others, and then the saints had meekly to submit with a large number of qualifications to these, or the sons and saints have never accepted them. They have never accepted gender equality. They have never accepted the rejection of afterlife. They have never accepted democracy. All the virtues of modern life, all the values of modern life. How many sons and saints accepted the demolition of the caste system which the constitution provides, abolition of untouchability? How many sons and saints recommended it? So this story about modern moral values coming from sons and saints is totally at par with the ignorance already displayed in textbooks by the NCERT textbooks by NCERT in that time. I would recommend this particular judgment to all colleagues and others who wish to know how far the Supreme Court has now gone in demolishing the concept of secularism. So religious instruction is not to be taught, but instruction in religion is permitted, when actually what it means is that instruction in one religion will be overwhelming. Now, there are other matters also here. When the Article 29 prescribes that no religious instruction can be given in any institution, educational institution, which either receives aid or even receives recognition for its certificates or degree, it applies also to minority institutions. Minority institutions, by inference from this provision, can make provision, and that is accepted by Supreme Court after much debate, can, under the present interpretation of Supreme Court, make admissions, can put admission quotas for minorities, religious and linguistic. But can they give religious instruction? That is not possible under Article 28. No religious instruction can be given on a compulsory basis by them. If they are religiously endowed, they can, as an optional, give this inscription. Now, this is very important because, unfortunately, when grappling with the fact that Muslim share of educated people and literate people is less than non-Muslims, when you grapple with the fact, then it becomes necessary for a secular state to take affirmative action. Affirmative action is now a part of the secular state to bring up backward elements to some level of equality. So affirmative action is there. Now, does this affirmative action entitle you to give grants to madrasas? Such madrasas, not like the Madrasa Board of Bengal, but such madrasas as elsewhere in the country that are religious institutions and provide religious instruction compulsorily to their students. Although there has been no objection to this from any important sector of public opinion that I can go on, I feel that this kind of effort is extremely dangerous. First of all, Although it has been said that madrasa education covers a small minority of Muslim students so far, nevertheless, if they are given grants, and in certain areas it has happened, madrasas have spread, where teachers are appointed at government cost. What is happening then is that Muslim boys and girls will study separately from non-Muslims. They will never meet a Hindu boy and girl. Hindus will never meet a Muslim boy and girl. I particularly shudder at this situation. And the task of the state governments and governments must be that if they find that Muslims of school-going age are not going in the same numbers as in other areas, then they should find the reason. And the reason generally is that there are no schools or very few schools in the Muslim areas. And that should be corrected. There are other measures by which they are being corrected. For instance, minority scholarships. They have, to my knowledge, greatly improved Muslim attendance in ordinary tax-paid schools. In a school for the deaf that I know, whereas previously Muslims were only about 5 out of 80 students, in my city now there are about 30 out of 105. And this is because they are all getting minority scholarships. Whatever small the amount, the very fact that the child earns a scholarship is an invitation to the parents to take the school seriously, where there were no fees previously. Even then they didn't send their children. Now they are sending children in proportion to their population, although the school is at the tip of the city and rather at distance from Muslim areas. Not because it was so situated deliberately, but because that was where the land was given. Now this shows that there are forms of minority affirmative action which are effective, but the madrasa support is obviously to appeal to religious sentiment. But I would like to underline the fact that it is totally in violation of Article 28, and I am particularly sorry that Mr. Sachar, who was a lawyer, should have himself by his recommendation undermined Article 29, which if you undermine really the protest against instruction in religion with the BJP prescribed, then you accept that. So it's a very dangerous precedent. First, the BJP's action was very dangerous in undermining Article 28, and now the Congress government's actions in supporting madrasa education by public finance without insisting that they should cease to be compulsory, to have education compulsory, and they should cease to have only Muslim girls and boys. And mind you, they also defy the formula of co-education, which is now thoroughly recommended for school education throughout the country. They have separate madrasas for girls and boys. So they defy the ordinary system of modern system of education in both respects, and yet you are funding those institutions. Both in relation to secularism and I submit in relation to actual mixing of students of different religions in our educational institutions. This is a very mistaken policy. Generally speaking, I regard the rather free way in which the judiciary has been commenting on religions as a very dangerous trend. I don't want to be hauled up like the Commander-in-Chief of the Indian Army, who I am very glad has been hauled up by the Supreme Court, but at least one can, without reading intentions, the Supreme Court said you can criticize, so let me criticize one judgment of a High Court judge, which is still in force. although its implementation has been stayed. Justice Sudhir Agarwal's judgment on the Ayodhya case. Now, it has all the merits of the English language with which the courts are embellishing it, and the religious point of view which is now openly taken by courts. Whatever, I am reading word for word, whatever we had to do, suffice it to conclude that the incidents of the temple demolition are not only confined to past, but is going in continuously, not going on, but going in continuously, full stop. The religion which is supposed to connect all individuals with brotherly feelings has become a tool of hatred, although it is spelled hearted, but that is the judicial spelling. A tool of hatred and enmity. The High Court condemns Islam, whatever it is today, as a tool of hatred and enmity. Now, I submit that this would have been inconceivable 25 or 30 years earlier. Totally inconceivable. One can't say Justice Gajendra Gatkar or Justice Bhagwati delivering such a judgment. Of course, one has to be very careful. And because you might be tired, I will end my lecture with a joke. You know Shah Bano judgment. My sympathies were totally with the divorced woman and not with her husband, although I am a husband. And my arguments with my colleagues who are professors and lady professors at that, who are all against the Shah Bano judgment, wearing green saris to go and protest in Delhi, was that you have probably only sons, you have no daughters. You don't consider protection of your daughters to be important. But anyway, that debate, you know what happened to that. But I was present when the High Court judgment was delivered, Supreme Court judgment was delivered. At that time, it used to be cyclostyle, and a copy was delivered to the chief lawyer, Mr. Daniel Latifi, who happened, he is now dead, to be my uncle. So I had gone in to see him. I didn't know that the judgment would be coming. And he said, Irfan, something terrible has happened. I'm going to see the Chief Justice, and rushed away. And then came back after half an hour. And he said, I said, what happened? Has the judgment gone against you? He said, no, the judgment is in our favor. But something terrible happened. I said, what? The judges said, Muhammad says in the Quran. You know, for most people it means nothing, but for Muslims, we know the Muslims believe that God speaks in the Quran, not Prophet Muhammad. Prophet Muhammad is spoken to by God. So but the judges just said Muhammad says in the Quran. They praised the Quran and they said that the Quran lays down humanitarian practices, and therefore Shah Bano judgment, the judgment in favor of Shah Bano, was perfectly in line with what the Quran says. But unfortunately, every time that they referred to Quran, they said Muhammad says in the Quran. So Mr. Latifi rushed to the Chief Justice, and the Chief Justice couldn't understand. He said, but Mr. Latifi, can God write a book? You see, of course, God can cause earthquakes, God can cause typhoons, but can God write a book? So Mr. Latifi said, yes, my lord, God has written this book. So he said, but what we can't say God says in the Quran, because we have no authority to say that. So he said, yes, but it is said Quran says. So I am all for these compromises. I also say the Quran says. I remain neutral. Neither God speaks nor Muhammad speaks, but Quran says. This is what Islamists do the world over. So I am all for compromise in religious matters. There is no need to step on toes of anyone. And the Chief Justice did right when he had the whole judgment cyclostyled again with Quran says replacing the earlier phrase. And so the opponents of Shah Bano judgment never came to know what a particular weapon against it they had lost by Mr. Latifi's intervention. So I'm all for very respectful attitude towards religion. Respect, yes. Courtesy, yes. But in substance, no. Civil law must make all men and women equal. Civil law must remove all disabilities of caste or community. Civil law must support affirmative action, but affirmative action of the sort that brings people together, that really helps the backward classes and religious communities to come up and not separate them from their others who are after all their brothers and sisters. In a recent review, and I shall end with that, I pointed out to a Mughal report where a Mughal soldier from the Punjab serving in the Mughal army in Rajasthan during Aurangzeb's time went to his commanding officer and said that the Mahajans of his village in the Punjab have been subjected to a raid and lost their property. So I should be given leave so that I may go there and protect them, because they are one with us. Except in matters of religion, they are one with us like relatives and brothers. I am translating the exact words. Now, this should be the spirit today, more than 300 years later, that we should promote. Religions should be respected, but there is a brotherhood beyond the boundaries of religion, and that we should celebrate and that we should strengthen. Thank you.